Good evening, ladies and gentlemen. Welcome to Reference Point. I'm your host, Dave Kocharhook. This evening, we're going to talk about a topic pertaining to businesses, starting businesses. We're in a part of the country that has a tremendous amount of entrepreneurial spirit. And with the little bit of positive activity in the economy right now, more and more people are considering starting some type of a business. But I have some questions about that. So I asked Mr. Dixon Howell, who's an attorney here in the Bay Area with the Business Law Group, to come and join us this evening to talk a little bit about types of business, sole proprietors, partnerships, LLCs, all that sort of thing, because I think it's important to understand if you're going to start a business, what do you need to know from a legal perspective in order to be in compliance with the various authorities. So Dixon, thank you so much for joining me tonight. It's a pleasure to have you here on Reference Point.
Oh, my pleasure, Dave. Thanks.
So you've been in the legal profession and working specifically in the area of business law for quite some time, correct?
Yes, longer than I care to admit, frankly.
Well, I like that answer. That's a good. I can use that sometimes. And I guess you gave me a little bit of data, and I think it's worth of noting that you went to what is it? I don't have my glasses on. I'm going to grab my glasses, Dixon, so I can read this. It's the Bolt Hall School of Law at the University of California at Berkeley. So that's where you got your degree.
Yes,
at Berkeley.
my law degree. Yes.
Your law degree. Okay. And most of this time you've been practicing here in the San Jose area. Is that right?
Except a couple of years after law school when I worked in downtown Los Angeles. Yeah, we came and opened the office in San Jose after that. That was in 1969, so it has been a while.
It has been a couple of years. And the firm that you're with right now, it's your law firm, right?
Yes.
Okay.
Yes.
And my understanding is that you tend to focus on things that pertain to business law, contracts, starting businesses, formation, and that sort of thing.
Right. We're business and corporate lawyers, basically involved with that in that area. Yes.
Excellent, because that's the whole thing about what I was hoping we could talk about tonight. Because like I said at the introduction, there's a tremendous amount of entrepreneurial kind of activity that goes on along here. And there's a lot of different ways that somebody could form a business. And I always wondered, how do you figure out what's the right way to go? You can have a sole proprietorship or a partnership. You can have an S Corp or a C Corp. You could have an LLC. You could have all kinds of different possibilities. But how does somebody go about trying to determine what's the right way to do it?
Well, there are really four basic entities. There's the sole proprietorship, as you mentioned, the partnership, the corporation, and the fairly new limited liability company. Just about all of the business entities that you mentioned fall under one of those headings. A couple of them are default, what you'd call default businesses. If you don't do anything else, you're going to wind up probably being either a sole proprietorship or a partnership. If you want to start a business by yourself, or perhaps you and your wife, don't do anything else, you'll be a sole proprietorship. If you've got two or more people involved in a business together, unrelated people, don't do anything else, you'll be a partnership, whether you like it or not. So by default, you've got these two entities. Now, the problem with sole proprietorships and partnerships, or one of the problems, is they have what's called unlimited liability, unlimited personal liability, so that if you should start a business and it should go bad for you, your personal assets are subject to the reach of the creditors of that business. That's true of both a partnership and a sole proprietorship.
So that's that, you said unlimited
liability.
Personal liability. So if you start a sole proprietorship or a partnership, or you start a business and you don't do anything other than just get it going, you're going to automatically either be a sole proprietor or a partnership if it's somebody that you're working with that you're not related to. And
That's
then you
right.
end up, okay. But don't you have to do some kind of filing of information that says I'm doing business and this is the format in which I'm structured?
Well, I mean, you may be referring to the fictitious name, business name sort of thing. I mean,
Sure.
if you're doing business as Joe Blow, and that's in fact your surname, or Blow is your surname, you don't have to file one of those fictitious business name statements. If you're doing business as Joe Blow and Sons even, or a Joe Blow Company, then you do, because that business is not the same as your surname. Same thing with a partnership. If you do business in a name other than the names of the principals, the surname principals of that partnership, then you're doing business as a fictitious name, and you're required to file a little fictitious name statement with the county clerk, basically.
Okay.
And
But if my business is my name, if it's like Dave Kocharhook, that's it. I could have I don't have to. I'm automatically there, and I don't have to file a fictitious business name because that's who I am.
that's correct.
But if it was Dave Kocharhook Auto Body, my name appears in it, would I still have to file a fictitious business name?
No. As long as you were the only person related to the business, Dave Kocharhook Auto Body would be fine. But Dave Kocharhook and Sons Auto Body or Dave Kocharhook Company Auto Body, then you would have to file one.
Because you don't necessarily know who the sons are or who makes up the rest of the company.
Right, and that's the whole purpose of that statement, is to kind of, once you file it, and there's a little publication that you have to do as well in a newspaper, to let kind of the world know who these people are that are doing business under this fictitious name.
Okay, cool. All right, so that's the default thing. If you don't do anything else, you're either going to be a sole proprietor or a partnership, and if the name of the business is beyond just your name as the principal, then you need to file a fictitious business name statement. Some people call it a DBA or whatever it happens to be. All right. But then you mentioned that there are two others. You mentioned the corporation and the limited liability company.
Right. I mentioned that the sole proprietorship and the partnership basically provide for unlimited liability for the owners. Okay.
Right.
So if you're in an industry that's particularly litigious or risk prone, and you're concerned about liabilities in excess of insurance coverage, for example, then you want to either form a corporation or a limited liability company, because these entities provide limited liability. They provide a legal shield to protect your personal assets against the claims of your creditors.
Okay.
So that's, in this day and age, that's probably the number one reason that people form these entities, corporations and limited liability companies, because of the protection, the personal protection, the protection of your personal assets, which they afford.
Right. Now the LLC and the corporation are a little different, and my understanding is that the IRS considers them differently as well. And so, are there distinct advantages of one over the other, or is it pretty much depend on what kind of thing you're going to be doing?
Well, it's a little complicated and depends on a lot of different factors, but basically they both provide limited liability protection. The corporation is a little more involved than a limited liability company, in that once you form it, you're required to do certain things, have annual meetings, things like that, shareholder meetings. The limited liability company, and again, it's kind of a new development. You don't have to do those things. You have limited liability, but you're not required to have these meetings of shareholders, and well, you don't have shareholders, and things like that, right? Yeah. There are some different tax aspects too. The corporation is an entity that's taxed kind of at a double tier. There's a taxation at the corporate level, and then there will be taxation as to amounts of money or whatever property distributed to shareholders. So there are two levels of tax. A limited liability company has just one. It's taxed like a partnership, so that it's what's called a flow-through entity. So in a way, it combines the best of the partnership and the corporation. Gives you limited liability on one hand, but also provides for a flow-through of these tax attributes, which in some cases is an advantageous thing to have.
So what would cause one to consider that the corporation might be a preferred methodology than the LLC?
Well, a corporation, for one thing, is, generally speaking, an easier way to raise money. If you've got a company and you're looking to bring in investors, for example, it's generally speaking easier to sell shares of stock than it is an interest in an LLC. So that's right off the bat. Generally speaking, if you are going to be a manufacturing entity involving the hiring of a lot of employees, I generally recommend that you go the corporate route rather than the LLC route. The LLC route is a wonderful vehicle for real estate businesses, because again, real estate has things like depreciation which flow through and things like that. So, but sometimes it's a close call, and sometimes fairly small startup businesses, they will want the LLC just because they want the protection, they want the pass through, and they don't want the hassle of annual minutes. It's a little less, and other things that lawyers do and are paid to do. So, so in that sense. people prefer that.
Now, if you're going to either do the corporation or the LLC, you have to, here in California, you have to file with the Secretary of State in California.
Yes.
And you fill out some paperwork, and then you wait for them to send something back to you with a little seal on it that says, here you go, here's your number. Do you have to wait until you receive those documents before you can actually begin to transact business?
No, as soon as you know that in fact you have been formed, and if someone phones you and say you've been formed, you're in business, usually there's a number attributable to that. You are in business, you can conduct business at that point in time. The practical problem is that there are a lot of things you can't do without proof of that status.
Sure.
I mean, you can't open a bank account. Any banker is going to want to see a copy of your articles of incorporation or of your articles of organization in the case of an LLC. So,
right.
So as a practical matter, and plus you're going to need a federal tax ID number. So you
Right.
have to get that. You can't really get that until you've got all the information on the formation. So while theoretically, sure, you can operate, as a practical matter, you probably are going to wait until you get your paperwork back from Sacramento.
Got it. And how long does that take?
Well, it depends what you're willing to spend. In our office, we tend to tell people that probably it's going to take about a couple of weeks. We have a fellow that we work with up there who basically hand carries our stuff up and files them. But even with that, there's a backlog in Sacramento that takes roughly a couple of weeks to get it all done. Now, for a fee, for an additional sum of money, you can pay this and it will be expedited and you actually can get formed
So
in,
you can
in
pay
a day
the
or
state
two.
an expedite fee.
That's
Okay.
right. And it's, as I say, it's usually $300 or $400, something like that.
Now, I've seen a lot of businesses, Dixon, who have incorporated in a state like Nevada or Delaware, and then they're doing business here in California and that sort of thing. And I've never quite understood what the advantage to doing something like that is, or if there really is an advantage. I mean, you're doing most of your business here in this state, so why incorporate in like Delaware or Nevada?
Well, Delaware is kind of a special case. Delaware is the state that's favored by venture capitalists and investment bankers. So if you have a hot high-tech company that you expect to take public at some point, you are ultimately, almost without a doubt, you will be a Delaware corporation. But that could occur after you were formed in California. You could actually later do that. But Delaware is perceived, either rightly or wrongly, as a little more favorable, both the courts and the law, favorable to management of companies, of corporations, as opposed to the shareholders. So that can be important to venture capitalists and investment bankers. People incorporate in Nevada generally because there's no income tax in Nevada. But if you are a business operating in California, whether you're a Delaware corporation or a Nevada corporation, you will have to qualify in California to do business.
Right.
You will have to do a filing in Sacramento with the Secretary of State's office, and you will be subject to a lot of the same rules that California corporations are. So in a sense, it doesn't make a lot of sense, at least in the early embryonic stages of a business, to form other than in California.
You're still going to end up, if you do something like that, and most of your work is here in California, and you're earning your income in California, you're going to pay California income taxes, even though you incorporated in Nevada.
Correct.
So the net positive is there isn't a net positive necessarily.
The state of California is going to make sure that they get their pound of flesh
They
for
get
your
their share.
for your business activities in California. Yes.
Right. Now you mentioned that you can make changes. Now, is it difficult if you start out a business as a sole proprietor, or you start out a business as an LLC, and then you're looking to, for whatever reason, to shift it to a corporation? Is that a complicated thing? Is it?
No, it's not particularly complicated. You can fairly easily incorporate a sole proprietorship or a partnership or just about anything else. What you have to keep in mind is that with respect to the entities like an LLC, before that's combined or merged with another entity, you're probably going to have to be involved in making sure it's properly liquidated and properly dissolved. So there is that little complication. But generally speaking, through either a sale or merger or something like that, you can combine entities and wind up with in a different form than the one you started with.
So if I had an LLC and I, for some logical reason, wanted to now make it a corporation, do you start the corporation first and then buy or absorb the LLC, or can I just file some papers that says I'm changing my colors here now? I'm no longer an LLC. I'm going to be a corporation.
No, you just can't flip a switch. You've got to go through some manipulation to either merge it into something else, either with tax consequences or without tax consequences. You have to dissolve the old entity, make sure it's properly liquidated and dissolved. You just don't flip a switch and do that. You actually, there is a kind of a movement, a flow, a merger, whatever, one entity into another.
Can you do that in a manner that doesn't prevent you from continuing to operate? I mean, you set up you're going to dissolve the LLC and start a full C Corp, and the timing is such that all of these things flow into each other, and I don't have to, therefore, not be doing business for 3 months because...
No, not a problem. That can all be worked out, and the transition most likely is going to be a very smooth one.
Cool, got it. The other thing I was curious about is I've heard C Corp versus S Corp and this sort of thing, and I wasn't sure what the distinction, if we're talking about a corporation now, what are the distinctions for that type of a thing, and why would you choose one over the other?
Well, again, both are corporations. Both the C Corp and the S Corp start as corporations. The S Corporation makes an election, a federal tax election, to be taxed as an S Corporation, which in effect means it's being taxed as a partnership. Getting back to that prior discussion we had about flow-through entities and things like that. So you have the corporation electing to be taxed as a partnership so that the profits, the losses, whatever, flow through to the shareholders of that S Corporation, kind of in their percentages of ownership. So that particularly in some startup situations, for example, of businesses, they tend to lose money in the early years. Let's say you have a couple, and they're opening a mom and pop store, and they expect to incur losses. The husband works in high tech; he's got a good paying job. By making that subchapter S election, they can actually use those losses and apply them against the other income in the couple, and it's a little bit of a tax benefit there. So. That's certainly one reason people make these S elections in early years. Now you can later terminate that election once you become profitable too. So, but basically it has to do with tax attributes and taxation. The corporation, in the normal sense, it files a tax return, pays tax on it, and the individual owners file their own. An S corporation basically files just a kind of an information return, like a partnership. It's a pass-through of attributes to the shareholders.
Got it. I didn't understand that. That's interesting. So here in the Valley, do you see, I mean, you're involved in this type of work all the time. So what do you see as, I guess my question is, one form of structure seem to be more prevalent here in the Valley than others?
Oh, I really wouldn't say that. I would say probably in our practice, you're either going to be a C Corp, an S Corp, or limited liability company. Certainly those three. Right now the limited liability company is real hot. It's fairly new. It's only been around a few years. People are a little bit enamored with it. Again, they like the idea that they can get limited liability protection without having to prepare corporate minutes and things like that. But as I say, there are times when it really isn't appropriate. But all three of those are quite popular right now.
Cool. All right. So it doesn't take very much time to start one of these things up. If you're going to start a business and you have a concept and you have a plan and everything, you can start your business pretty rapidly in almost any of these formats. Then, I mean, it might take a couple extra weeks to get the paperwork back from the state if you're doing a corporation or a limited liability company, so that you have the documents you can take to the bank. But it really doesn't take enormous amounts of time, so people can really get things fairly quickly operating then.
Sure, but like anything else, all we're doing is forming the entity. The entity will have to be normally funded in some fashion. I mean, you open a bank account, you have to usually put some sort of investment capital at risk, particularly with a corporation. And also with a limited liability company. You have to do what I call play the game, which means that you have to adequately fund it. It has to be. Can't just necessarily be funded with a shoestring. You have to put some reasonable capital up at risk to provide your future creditors with protection that in fact they will have some chance of being paid. So forming it is easy, but then it has to be funded, and Of course, there's a whole bunch of other kind of legal work, boilerplate in some cases, which lawyers have to do to flesh it out, to do the corporate bylaws, to do, in the case of a limited liability company, it's called an operating agreement. These rules of the road, if you will, for operation. So that's all additional work that has to be done after the basic entity is formed and the basic shell is formed. But that, again, can all be done fairly quickly, yes.
Is there any structural distinction between a private corporation and a public corporation? There's all this talk right now about Facebook's about to have their IPO, so they're going to be a public company traded on one of the stock exchanges or whatever. Is there a structural distinction between a private corporation and a public corporation?
Well, when you say structural, I mean they're both corporations, but the more shareholders that you're issuing to, the more the Securities and Exchange Commission is involved in approving. You have to go through quite an extensive procedure to go public, and with all sorts of filings and disclosure of information to your potential investors through the SEC and through the California Department of Corporations. So fundamentally they start the same, but once the money starts to pour in as a result of the sales of shares, there's a big difference between a little mom and pop corporation, closely held corporation, and something like these big high-tech companies like a Facebook.
Right. Got it. So let's go back to the idea of the corporation or the limited liability company having a layer of protection for the owners so that their personal assets are not subject to the creditors of the company. Is there something that you have to do as a business owner in that structure to ensure that that protection stays in place? Can you mess yourself up if you're not careful?
Absolutely. And there's this doctrine called the alter ego doctrine, or piercing the corporate veil, that you may have heard of, where you've had a corporation that's been set up, or a limited liability company, but because it wasn't properly set up, wasn't properly maintained, once it goes down the tubes, the creditors can come in and basically pierce the veil, claim that you didn't operate by the rules of the road, you didn't play the game, you didn't adequately capitalize your company, you didn't have your annual meetings if you're a corporation, you commingled assets, there wasn't a clear division between what the corporation did and had and what the individual shareholders did. So you can get a lawsuit that will file against you in which they will try to get a judge to disregard that corporate entity. So that's why you need to do all these formal things, have the meetings, see that it's adequately capitalized. And many of those apply to both corporations and limited liability companies. The one thing that doesn't apply to the limited liability company is the not having those meetings.
Right.
If you're a corporation and if you never have any meetings, that's again one factor among many which are used to possibly enable creditors to pierce that corporate veil.
It sounds like that the wise individual will seek some clear counsel in trying to make sure that they understand the best way to do this. And I got to tell you, I've seen this for the internet is a wonderful and yet a cursed thing at the same time, because you can go up on, LegalZoom and various and such other things that claim that we'll do this for you for $2.96 and it'll be done in 27 seconds. And that's not necessarily the case, though. So you're sort of like anything else, you have to watch out for the source that you're actually going to for information.
Yeah, I can't tell you how many clients have come into me and after using an entity like that and thinking they were just properly set up, I'll just look at it and it's just all skin and bones. They haven't done it. They really are vulnerable to a piercing the corporate veil attack if that should arise. And it's the old adage, you get what you pay for. And
right.
You're much better off having someone do it that knows what they're doing. I mean, these other entities will get you formed. They'll get you formed in Sacramento, and that's when they'll probably say sayonara. They might give you some boilerplate documents that you may know what to do with, or you may not. They probably won't issue stock for you. I mean, they probably won't do a lot of things that, again, competent counsel will do.
Right. So I have another question I want to ask you, Dixon. We're here in the Valley. There's a tremendous amount of starting up businesses where intellectual property is part of the deal, or and if you have an idea about something and you're going to take that idea forward, how do you protect your intellectual property? Is it different? I mean, if it's part of the corporation, is that all you need, or is there some sort of filings that are smart to do relative to intellectual property that are different than anything else?
When you say intellectual property, there are all sorts of different types of intellectual property. I mean, the bulwark, I suppose, is the intellectual property that's patentable. I mean, then you get yourself a patent. I mean, if it's something that's patentable, you'll want to do that.
Right.
Employ patent counsel to actually see that a patent's issued in Washington, D.C., which is the ultimate protection. Short of that, trademarks and copyrights and things like that, you can establish those as well through certain filings in Washington and in Sacramento. You want to, with all your intellectual property, you want to, probably the watchword in my view is to memorialize it, write it down along with the date that you came up with it. But yeah, there are filings that you can also do to further your protection.
Cool. And if anybody wants to know some of the particulars on that, what I suggest you do actually, I've got all these resources that you folks who've been watching Reference Point for a while know. So if you have questions about anything that Dixon and I are talking about tonight, send us an email at info@referencepointtv.com. I'll make sure it gets to him and he can answer any specific questions for you pertaining to the structure of your corporation, whatever it happens to be. I mean, because that's his, you're the expert in that area, and I appreciate that. So we've got just a couple of minutes left in the show tonight, Dixon. So I wanted to see if, is there anything else that I should have asked you regarding this that we haven't talked about that you would like to convey to the viewers?
Well, just that it may or may not have been apparent from our discussion that this whole area of choice of business entity is a somewhat complicated area involving corporate law and tax law and a lot of other things. So it is a somewhat complicated thing, and I think it is important that you put yourself in the hands of somebody who knows what they're doing, and probably not do it yourself. I mean, unless you really want to roll the dice. I mean, you as I said before, you kind of get what you pay for, and you seek adequate counsel.
Great, and I think that's a fantastic way to end the conversation. So ladies and gentlemen, we appreciate the fact that you'll watch us here at Reference Point. Now I hope this information about structuring businesses has been useful, and let's take the suggestion to heart. Don't necessarily just run out on your own and think that you can do this without getting input from a professional. So that's pretty much it for this evening. Dixon, I want to thank you for joining us here on Reference Point. It's been very informative for me, and I hope for the audience out there as well. So ladies and gentlemen, don't forget to send us those queries at info@referencepointtv.com, and we'll see you next time here on Reference Point.